Everyone, as I said earlier, I'm sorry to start a bit late, but hey, I'm still here to deliver to you the Legal Hour show, proudly sponsored by CITI Law Solicitors. Tonight, my topic is long residence, making application under the 20-year route. For those of you who have lived here for 20 years and are making plans to make an application to regularize your stay. And I'm going to take my time, obviously, to look at evidence, documents, what you need to make those applications. And the topic is making an application under a long residence 20-year route without sufficient or enough evidence. So most of you will have difficulties being able to show that you have documents that allows you to make those applications. And therefore tonight I'm going to take my time, as I do always, to take viewers through this and ensure that I guide them to other alternative evidence that they can confidently rely on it and make those applications. Because there are many times that people are of the view that they don't have those evidence or documents, so they feel that they can't make those applications. And many times we are speaking to people, they are saying that they've been here for 20 years, but they don't know how to make those applications because they don't have anything to show for how long they've lived here. And I understand the challenges they go through because of the laws of this country. But at the same time, I am here to guide you. I am here to explain to you that there are alternative evidence that you could equally rely upon to make successful application under the long residence 20-year route without sufficient evidence. So please, if you have just joined me, I do this show every Tuesday, normally from 9 p.m. tonight. I'm starting a bit late. And then on Wednesday we have the Tree language with MC Chaka, and we take our time to explain everything we've discussed on Tuesday in Chi on Wednesday. So you can join us both days and we'll be happy to welcome you on board as we take you through the Legal Hour show, proudly sponsored by CITI Law Solicitors. So guys, tonight is as simple as explaining to you what you require to meet the requirements of making application under the 20-year route. And if you have to make that application, what do you need in order for that application to be successful? That's what I'm going to do tonight. And I want to urge you to share the video with your friends and family members. I'm going to go on a short commercial break. When I come back, I will take my time to explain to viewers what I'm here to do tonight. So please don't go away. thank you very much for your patience. As I said earlier, tonight I'm looking at the 20-year long residence. And obviously I'm going to look at specifically what evidence one will need to make successful application under that route. Now, to start with, I must clarify here that there is no longer what they call the 14-year rule, because that was something that was abolished since the 7th of July 2012, and it was replaced by the private life route, which is for those who have lived here continuously for 20 years, unlawfully in most cases, or part of this could be partly lawful and then unlawful. And those people will then be eligible to make application under that route, and if they are successful, they will be granted 30 months under what they call a 10-year route to indefinite leave to remain. So it means that for one to get indefinite leave to remain as an adult who will be here after the age of, for example, either 18 or 25, that person will have to remain in the UK for 30 years before they eventually get indefinite leave to remain. But surprisingly, there are many people who have lived here for the 20 years, and they are still having difficulties making applications. And the reason they are having these challenges or difficulties is because of the fact that they are unable to provide documentary evidence to show how long they've lived in the UK. And that difficulty means that most of these applications will either be refused or they are unable to even make the applications at all because of sometimes the cost involved. And therefore tonight I'm here to take my time to explain, to point out the viewers to alternative evidence that they could rely upon when they are making those applications. Now I'm going to make my submission very succinct, at the same time making sure that I give enough detail for people to understand how they can make application under the 20 years long residence route without enough or sufficient documentary evidence. That's what I'm going to discuss tonight. And I want to urge you to obviously share the video with your friends and family members so that they can equally benefit. Invite a friend to invite a friend, remind a family member to invite a family member, and let all of us build a community of knowledge, because knowledge is power. So, normally we have two rules. We have paragraph 27B, which is normally for people who want to make application under the 10 years lawful residence. And those people will normally have to show that they have lived here continuously and lawfully. And the definition of lawful residence is enshrined in various parts of the immigration rules, including paragraph 39E. But I'm not here to bore you with legal jargons. I am here to explain the distinction between the two. And most specifically, those of you who have been here for 20 years and want to make application under the 20-year long residence route. So when one is to make this application falls under the private life route. So when you lived here continuously for at least 20 years, then you are eligible to make application to be granted leave to remain so that you can regularize your stay in the United Kingdom. So, as I've said, this residence or continuous residence can be a combination of being lawful at some stage, becoming unlawful at some stage, becoming lawful at some stage, and you can combine all of this cumulatively. And once you have combined all of this cumulatively and you've been here for a total of 20 years, then you're automatically eligible to make application. Now, so under what circumstances would the 20-year route application be refused. In fact, it will interest you to know that there are very limited grounds for refusing the 20-year route application. Why? Because you only have to show that you've lived here for 20 years and it doesn't have to be lawful. So in most cases, these applications are either invalid for those who have not gone for their fingerprint, or they are either refused under what they call suitability grounds. For example, those who have committed criminal offense in the past and have failed to disclose it. So you see that there is very limited grounds for refusing this application, which means that in most cases, majority of these applications needs to be successful. So it then means that the only reason why some of these applications are going to be refused, apart from those who may have problem with suitability, which is having criminal convictions and all that, is the fact that majority of people will not be able to show that they have lived here continuously for 20 years because they lack providing the documentary evidence to support that application. And that is the main reason why I'm here tonight. So in most cases, people, when making these applications, they need to show continuous residence. And I want to take a minute of your time because I want to take my time to explain this and give viewers alternatives. Now, what I'm holding here is one of the applications that we did for one of our clients recently. And of course, that application was successful. And when you look at the part 2, which is part 2, missing relevant information, most lawyers will be familiar with this. Normally, when you submit an application, then Home Office, if they feel that something is amiss or some of the documents are say required from your client, then they will normally send you further requests or requisition of further documents. Now, so this particular paper I'm holding here gives list of documents that Home Office was requiring from our client to provide. So tonight I'm looking at documentary evidence. And I know that most of you will not have this documentary evidence. But that doesn't mean that you are not eligible to make application, because I'm going to show you the way. So Home Office, obviously, because our client has been here for 20 years, they are requesting for documents for let's say 2021 or 2022 up to 2020 or 2021 or 2002 to 2022. And these are the list of documents they are asking for. Letters or documents from government departments or agencies, for example, HM Revenue and Customs, Department for Work and Pensions, DVLA, TV license, letters of other documents from GP, hospital, other health services, medical treatment, appointment, home visits, other medical matters, bank statements, building society savings accounts, council tax bills, statements, electricity, gas, water, mortgage statement, tenancy agreement, telephone bills, letters from schools, nurseries. So the list is endless. And these are documents that mainly is so difficult for somebody who is living here illegally to be able to obtain. And that 20-year rule is for those who have lived here illegally for 20 years. And the documents they are asking them, the Home Office is asking them to provide in order for them to be successful in their application, are the very documents that in most cases they are not even able to have it. For example, we know that there is a law that forbids people to have bank accounts if they are living here unlawfully. And We are all aware that most of the banks, if they find out that you don't have papers, they will close your account. And they have done that for a lot of people, that they've closed most accounts of people that I am personally familiar with. If you do driving license, in the past probably you could have had driving license, but recently, and a new law came a couple of years back. If you have a driving license and you don't have papers, it's more likely to be revoked. You can't have it. Letters from HM Revenue, wage slips, bank statements, pay slips. You can't get letters from HM Revenue if you were not living here lawfully and you have never worked in your name. So these government agencies' letters, you can't probably get them because you've never worked, you've never had national insurance number. Some of the documents there about GP appointments, some people don't even have GP in this country. It's amazing that this is true. Yes, they don't. So some of these letters, they can get them. Electricity bills and gas bills. Whoa, of course, there is a new law. Landlords are not allowed to rent out properties to those who are living here illegally. And therefore, if a landlord was to rent a property to somebody living here illegally and allow the person even to have electricity and gas in their name, that landlord is committing an offense, and he can receive civil penalty, notice, or charge. Just as employers, when they employ illegal immigrants to work for them, they also get civil penalty notice. And some of them can be charged as much as £15,000. Landlords can also be charged. Tenancy agreement, law forbidding landlords to enter into tenancy arrangement with those who don't have leave to remain in this country. So we see that the very documents Home Office is asking applicants to provide are the documents that the law forbids them to have in their names. Banks, they can't. TV license, it shows you are renting, you are not supposed to have it because landlord can't rent out a property to somebody who is living here illegally. Pay slips, you can't have them because you don't have the right to work. HM Revenue letters, you will not receive them because you've never had that right to work. So when you look at the list of documents that the Home Office is asking people to provide in order for them to be successful in the application for living here continuously for 20 years, they are the very documents that there have been various laws in place that have been implemented to prevent them, to stop them from having it. Therefore, most of these people who have been here continuously for 20 years are in limbo. Why? Because they can't provide this documentary evidence. And even if they do, yes, some people perhaps were working, because when I started my presentation this evening, I said that this 20-year rule is a combination of those who have lived here lawfully and unlawfully. So some people probably came in as students, eventually the student visas were expired after they have completed their various courses and became illegal. Some came in as a spouse, one reason or the other, their marriage broke down irretrievably, they were not able to get their indefinite leave to remain, and they became illegal. Some people came here as children, or some people came here with visit visas, or some people even came here with working holiday visas. Some people came here with visas that allowed them to work, but eventually became illegal. So some of these documents, some people can have it, some of them, but they might not have it after a period of time, because if you were working, you were probably going to get some payslip and P60s and letters from HM Revenue. But for the moment you stopped working, you are not going to get those letters anymore. And another way, you're going to get P60s and payslips because you were no longer working. Bank statements, when the bank found out that you had a bank account and you didn't have papers, they closed that bank account. You can't now have tenancy agreement because the landlord will be committing an offense by entering into tenancy arrangement with you when he's in full knowledge that you are living here illegally. Just as employers can be fined to the tune of 15,000 if they are found to have employed somebody who doesn't have right to work without statutory excuse. So you see the challenge here. However, I'm now looking at the continuous residence. Now, unlike those who have lived here continuously and lawfully for 10 years, who are supposed to show that they have not been absent for 448 days throughout their stay in the United Kingdom. Because if you did, there will be a break. The distinction is that if you are making an application under the 20-year route on lawful residence, that's the distinction, then you should not have been away continuously or total of 550 days. I want viewers to take notice of this. Whilst it's 448 for the lawful residence, 10 years, it's 554 unlawful residence. So the total of the 20 years that you've been here, when you are putting your documents together, in total, if you are short of evidence that 550 days in the total of the 20 years you are not in this country, you are out. So that continuity will not be there. The other point is, those of you, of course, if someone is living in this country illegally, and sometimes some of you, whether you were working in a place in a different identity and you were apprehended by the enforcement officer, sometimes you could be sentenced and perhaps receive 6 months or a year custodial sentence. I have spoken about the continuity of 55 days. For those of you who have been sentenced or have received custodial sentence, this is what I want you people to take from this presentation. It doesn't break the continuity of your 20 years residence in this country. Rather, it will be discounted. So let's say you came into this country 2002, June. So that 2002 June, you've been here continuously up to 2022 December, which means that you were eligible to make an application in June 2022, because from 2002 June to 2022 June will be 20 years. But let's say in the course of this period, you had a problem with the law and you were subsequently convicted and sentenced, given custodial sentence for 6 months. Being in prison doesn't mean that you will not have the opportunity to make application under the 20-year rule. But it could affect you in two ways. First, it means that you will not be able to make application in June 2022 because the period you spent in prison doesn't count towards your continuous unlawful residence in the United Kingdom. Take note of this point. So which means that you will probably be eligible to make your application cumulatively in December 2022 by discounting that 6 months you were in prison, but it doesn't break your continuity of unlawful residence. Since I'm talking about those who have been to prison in the course of their 20 years in this country, it's also important that I also confirm this. I've already said that in most cases, for city law, most of these applications that we've done, majority of them have been granted. Yes. Because the only grounds that these applications can be refused in most cases is suitability grounds. So if you have been in prison, it doesn't affect your continuity. However, if you don't disclose it, when you are making an application, then it could affect the suitability. I have a client that I wouldn't go to DK because of confidentiality. When lawyers that were dealing with a case of this nature failed to disclose this information, and eventually the application was automatically refused. And they were a bit confused. It is not because that person was in prison. That is why the application was refused. Because being in prison doesn't affect your continuity of residence as unlawful resident. Rather, not disclosing it fails under the suitability grounds. So that's point number 2. For those of you who have had problem with the law and probably would have received some custodial sentence and serve it and still continue to remain in this country, and you want to make application under the 20-year unlawful long residence. Now, coming back, I have discussed 2 major points here: the cumulative or discounting period spent in prison, taking into account 550 days of the entire 20 years to be discounted. So it means that you are allowed to have documents save the 550 days, continuously for 20 years. And I've already mentioned that most of you will not get these documents because the law forbids you from having them. So where do you then get evidence? Because if you don't also show, remember that I've told you from this presentation that if it's found out that you left outside the United Kingdom in the course of your 20 years stay in this country for more than 550 days, then you will not qualify under the 20-year rule. So you need to be able to demonstrate that you've been here continuously for 20 years, unlawfully, and you have not been outside the United Kingdom for more than 550 days. However, if you are not able to show any document in your name or to show that you are living in the United Kingdom, then you will not qualify under the 20-year rule. And the documents have just enumerated there quite clearly. Most of you will not have it. So the question is, how do you prove that you'll be here for 20 years? Alternative evidence. In most cases, for example, the Queen passed away recently. So if you were in this country and you took pictures during that period, those pictures is a landmark to show that you were in this country during that time when, in fact, that incident took place. And everybody knows that this is the date that they had the funeral. So obviously, if you have a picture that is connected to something of that incident, then it means that you were here, because if you were not here, you would not have been able to be associated with that occurrence. So that's one point. So you see that we could have various days of events occurring in this country. Maybe there were some strike. And I tell you what, in law practice, it's common sense. And most times, I am not here to brag, because most times we put it into practice and it works. What I'm describing here is synonymous to sometimes those of you who may want to even make insurance claim. If, for example, in most insurance claim terms and conditions, they will say that if you were traveling and there was a problem, let's say because of weather, because of some strike, not necessarily industrial strike, contributing to the fact that maybe there was accident on the road, there was a major incident on the road, and that incident was reported on certain media platforms. So let's say I have insurance that covers me for mixing my flight, and I say, whilst I'm going to Gatwick or Heathrow, there was an incident. There was this major incident that the road was blocked, and that's why I missed my flight. It means that I am trying to associate myself with that date when that incident took place, at the same time saying that it is that incident that caused me to miss my flight. So the insurance company in processing my claim, I'm just giving practical example here to tell those of you who don't have evidence to deal with your 20-year lawful residence. So as long as that incident has been reported, let's say on AA, then I can print it out and show to the insurance company, look, this is the date I was traveling, this is my ticket, and this is the incident that took place at this particular time. And this AA report shows that I could not have been able to drive smoothly to board my flight because of this incident. So you see, I have been able to connect myself with that incident and that date when the incident occurred in order to make my claim successful. So that's why I'm saying that if you have this list of documents and you can't provide them, then perhaps if you have pictures that connects you to incidents that has taken place, monumental incidents, then you could also rely on it and say, look, I was in this country at this particular time when this incident took place, and this is me in this picture showing that I was here. That is an alternative evidence. Probably you were living with your sister or a family member, and many years ago you didn't have any place to live. That person can also provide supporting evidence that during this period to this period, he was living with me and I was either the lieutenant here or the landlord at the time. That confirms that you were in this country, because you are not going to get some of this council tax evidence, because probably you are not even the lieutenant, even before the law changed to forbid landlords from renting to illegal immigrants. So that's a second option. There are many of you that belong to communities, organizations, Ghana Association this, Nigeria Igbo Community, Sierra Leone Yam Factory. All these organizations, some of whom are registered, may also confirm that during this particular period to this particular period, you were a member of the organization and you regularly attended their events. That confirms you were here. It is also possible that you are one that practices your faith. You believe in God, for example, or you are Muslim. And you go to church or you go to the mosque. That can also confirm that you've been a member for this particular period of time. Or you probably went to Tesco and filled some forms there, they sent you letters. Or you probably even bought some insurance, life insurance policy. They will send you letters. Because when it comes to the 20-year rule, what they are asking for is whether or not you can show that you have lived here continuously for 20 years. And therefore, even if you are unable to provide most of this documentary evidence, As long as you can show that you have lived here continuously for 20 years, then you will be eligible to make application under the 20-year rule. So remember, what you need to show is showing that you've lived here continuously for 20 years. And the specified documents does not necessarily mean that you will be able to provide the listed documents from government agencies, for council tax, for electricity bills, for cars, and all those stuff. But going further, I have always said here last time when I did presentation here, and this is going to be my last 2 points, I have dealt with not being able to provide the documentary evidence to support your application, and what other alternative evidence that you can look at to support this application, for this application to be successful. I am now looking at the fact that for those of you who have not lived here after 20 years, are you also eligible to make these applications? I've always said that in most cases, this route is private life. It means that in addition to this, you can combine this with family life. So let's say you've lived here for less than 20 years, but you are now in a relationship with somebody who has children, and you're not necessarily the father. Then here, which is Article 8, not just the private life aspect. So you can combine the two limbs and make successful application. There are those of you who might also have what they call exceptional circumstances, something beyond the norm that makes it quite extraordinary that you should be granted leave outside the private life route. And the third option that you can also add it to your 20-year rule, if you have not lived here for 20, is for those of you who are making these additional grounds of compassion, compelling or compassionate grounds. Some of you who probably are going through some treatment, you have some medical condition, even though most times, if it's not argued well, Home Office will tell you that, oh, we've checked, you can receive this treatment in your home country. But sometimes it's not just about the treatment. It's about the fact that maybe there's somebody here supporting you, and that support, because you have left your country for more than about 16 years, is no longer available. And I've said it here that most times when these applications are being dealt with, they are complex in nature. And therefore, clients need to be interrogated, and all evidence, including those that attract compassion or are exceptional in nature, needs to be added to these grounds. So tonight, I've had the privilege to discuss how you can make successful application if you don't have sufficient evidence. At this point, I'm going to obviously open the phone lines. If anybody has a question, you'll be free to ask a question. I started very late, and I think I've spoken for almost more than 30 minutes. So if you have a question and you want to ask, I'm going to put the phone lines out there. The phone lines is on the screen, and you'll be free. Or if you want to make any contribution, if you want to give a testimony, this is not a church, but of course we have clients, happy clients who may want to also say something about the service we are providing. Those who want to give us feedback, we are here, positive or negative, to receive it, because we are here to improve and to provide quality service to our clients. Now, at this point, may I take a few minutes of your time to advertise the areas of practice. Now, if you want to, this program has been proudly sponsored by CITI Law Solicitors. Whilst I'm waiting for anybody who has any question to ask, I'm going to simply advertise CITI Law Solicitors. And if you have any legal question whilst I'm going through that, you can ask your question, and I'll be more than happy to answer. And it doesn't matter whether it is to do with immigration. It can be personal injury question, it can be employment law question, it can be civil litigation, it could even be housing law, it could be family law. I am here well prepared to take all your questions, and it's free of charge. So CITI Law Solicitors, if you want to find where we are at Barking, Unit 113 and 122, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 118FG. Our office is very, very close to the Barking station. It's literally 2 minutes away, walking distance from the Barking station. And if you come out of the station, you just turn right, you'll find a KFC there. Once you walk past the KFC, there is a zebra crossing. You just turn right again and walk for literally less than a minute, and you see the Barking Enterprise building. That is where you can find us. If you want to contact us after I've left this studio, our office number is on the scrolling graphic. At the same time, I can mention it to you as 02033550782. That is the office contact number. If you phone me and you didn't get hold of me, my able colleagues and partners are in the office to assist all times. The areas we specialize in is immigration law, which is what I've been doing tonight. I enjoy doing this job, and it gives me joy when clients who have been separated from their children, from their spouses, when there is no hope in their cases, and the law is able to support them to be on their knees, on their feet. That is what we're here to do. So, in all areas under the immigration law, nationality, if you want to get sponsorship visa, or if you're a business organization, you want to get a license to recruit from abroad, if you're a family, you want to bring wife, husband, you need support to bring your dependents, we are here, all areas under the immigration law. If you want to naturalize, we are here to support. Employment law, if you have been dismissed from work, if you have been a victim of bullying and harassment or discrimination, we are here to assist. Family law, for those of you who, one reason or the other, you are suffering domestic abuse in your homes, you want to have non-molestation or occupation order in place, if you have been deprived of opportunity to have contact with your children, and you want child arrangement order in place, we are here to assist. And it's the unfortunate circumstances that you have to go through this divorce and you need help to secure your interest in the matrimonial asset. Again, we are here to help. Personal injuries and clinical negligence, those of you who have had accidents at the workplace or driving and you've been involved in an accident that was not your fault and you want lawyers to assist you, again, we are here to help. Commercial dispute and civil litigation, if someone is owing you, or if you are being dragged to the court and you feel that you need someone to defend you, again, we are here to assist. Housing law, mold killed somebody recently. In winter, most time there will be mold and damp all over the places. The windows falling off. Weather is so cold, and some houses are in disrepair state. Or you are being evicted unlawfully. Again, we are here to help. So guys, if any of what I have discussed here, if you have missed any part of this program is recorded and it stays on the CITI Media TV platform, my own personal profile, Thomas Bebel profile, and CITI Law Solicitors Facebook page, and our YouTube channel, CITI Law Solicitors. So these programs are recorded. You can watch them, and again, and again, and again, and again. And there is so much to learn. I know many of you that this program has been helping. And that's what gives me joy to be coming here every now and then to ensure that I can bring some smile to your faces. I have various people watching tonight, and before I leave the studio, I want to acknowledge you. I appreciate your presence. I am happy that every now and then most of you join us here. If this is the first time you've joined us, we do this program every Tuesday in English and Wednesday from 9 p.m. with MC Chaka in Tree. So I have Emmanuel in Kingsford. Mr. Cancer, thank you so much for joining tonight. I have highly favored Priscilla watching. I have Joe Chaka. MC Chaka is part of the team who is also watching tonight. I have Georgina Mfadi, who is watching here. I have Honest Prick, Christopher King watching. I have Onye Inspire. I have Nana Ya Julia Afrofi, who is also watching tonight. I have Ellen Mansa Adesa watching tonight. Tina Tamakru, who is always here with us, say hello. I have Alex Wilson watching. I have John Atta watching. I have Rachel Davis and the only chief of Commonwealth Hall, King Kofi Lancaster. Chief, I salute. I have Bismarck Adwampong, who is watching, and I'm sure, obviously, Ernestina Karokere will be watching Bismarck Adwampong. Thank you so much for joining us. Tonight, I have Elipulim Ameku. No, Amepu. Efo, is it you? I have Efo who is also watching here. I have Nana Ndamai. I think I have pronounced your name correctly. He said watching live. I have Ernestina Karokere. I said it. Once I see a Adwampong, I will see Ernestina Karokere. I have Amasewa Ado. I think you are all the way from Manchester, if I'm correct, watching live. So guys, it's been a privilege to have you here. Tomorrow, today I started a bit late because of workload, obviously, but I say I have to do this. But tomorrow, MC Chaka is going to be here, and it's going to be very lively. This is your opportunity to get free legal advice and send it to your friends and family members who require this free advice so that they can make progress in their lives. It's a legal choice. I always say that the problem most of us are facing is legal choice. Apart from medical condition, most of the problems we face is law. That's why we do these programs, to help the community. So thank you so much for joining us. God bless you. God bless you. Thank you. Bye-bye.